Please, because it's an online session also, if you'll make noise, online participants can't hear the session. Please.
Next slide. Yeah.
Good morning, one and all present here, and also the participants joining today. I welcome you all in today's guest lecture on new criminal legislations, that is, the Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Saksh Adhiniyam 2023. Today, we have with us a very notable speaker and also the former principal of this Pendakanti Law College, respected Professor Dr. Jay Kumar sir. I take up the honor, sir, to call our esteemed speaker, Professor and Dr. Jay Kumar sir, onto the dais. Please, sir. I would also request our principal ma'am, Dr. Arvinda, to please come onto the dais.
Chair is not there.
Okay, sir. Okay, sir. Yes. Now I request our cherished and beloved principal, Dr. Arvinda ma'am, to felicitate our guest. Thank you, ma'am. Now I request Deepa Tanisha ma'am, Assistant Professor at Pendakanti Law College, to introduce our guest for the session.
Good morning, everyone. I am honored and delighted to introduce our speaker of the day, Professor Dr. Y.F. Jayakumar, who is our former principal of Pendakanti Law College, Hyderabad. He is also a former professor and dean in Faculty of Law, Osmania University. He recently retired as a professor from Maharashtra National Law University, Aurangabad. He is also a visiting professor to Sardar Vallabhbhai Patel Police National Academy, Mari Chenna Reddy Institute of Human Resources, as well as International Center for Alternative Dispute Resolution. He is a life member of Indian Institute of Constitution and Parliamentary Studies, and also a member of Governing Council of Indian Law Institute. He authored 3 books on Horizons of Family Law in India, Consumer Law and Redressal Mechanism, as well as Human Rights and New Challenges. And he also authored a number of articles in legal periodicals. Professor Jayakumar sir has presented research paper in 5th World Congress at Halifax, Canada, as on social legal aspects of surrogacy. He also presented paper in Asian Law Institute Conference at Malaysia, as well as 9th World Congress at Oslo on reproductive healthcare justice. Professor is a subject expert in family law, constitutional law, alternative dispute resolution, as well as law of evidence. He is the coordinator for production of e-content program based on UGC. Apart from this, Professor Jayakumar sir is also an association with national law schools, universities and other academic bodies in India as a subject expert as well as an UGC nominee. As on today, sir has supervised about 15 PhDs in law of different universities in India. With that, I would request sir to start the session. Thanks.
Before proceeding further, I would like to give an introduction why this session has been held. You should get the background of this session, why the new laws have been introduced. After that, I would like to welcome the sir. We live in a world of variation. Laws and how they are implemented are always changing. and have been always changed. As Sapni quoted, the law is an organic growth. The government of India took the initiative to make the laws which are with the modern discourse on inclusion and rights as it evolved. In this context, today's lecture has been organized to discuss the changes brought over into the new criminal laws to align them with the today's need of society. The Indian Evidence Act, the Indian Penal Code, and the Code of Criminal Procedure have been replaced by the Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Saksh Adhiniyam, with a shift in the objective, that is treatment of crime, as stated by the Ministry of Home Affairs. Pre-independence laws were remnants of the past. Those laws were in accordance with the colonial rule to fulfill their aspirations and reluctance to deliver justice to the people. It had a legal structure that was not citizen-centric. In lieu of making piecemeal changes to the relevant acts, the Parliamentary Standing Committee on Home Affairs advocated in its 111th, 128th and 146th report for a thorough review of the criminal justice system. Consequently, in keeping with the goals of the democracy and the Constitution in establishing a citizen-centric legal system and making justice accessible and inexpensive for everyone. In light of the committee's recommendation, 3 new bills were introduced in the Lok Sabha again on December 19, 2023 and passed on December 20, 2023. The Rajya Sabha approved 3 bills on December 21, 2023 and on December 25, 2023, the President of India signed them into law. Now, I would request Sir once again and welcome you, Sir, to start the lecture. Thank you.
Dr. Aravinda ma'am, the principal of the college, Dr. Mohan Krishna, the senior faculty, Dr. Rajagopal, my colleague and former principal of this college, Padma madam, I am forgetting the same, this what we call Dr. Padma Square. So this is of the Pendiganti Law College, Dr. Sam Prasad and Dr. Shobha in absentia, academic coordinator, and young professors, those who are appointed after my what we say departure from this institution, and student friends of the Pendiganti Law College. So at the outset, I am very, very happy to see that this hall is full with the young and promising, we may call it as an advocates or law officers of this country. Our teacher, she made it very categorically, and she read my biodata, but in the biodata, one thing it was missing. Everything is covered. That is only external. What my contribution to this institution, probably it is missing. The reason is, when you are sitting in this, so you are all sitting in this room very comfortably. When I entered into the portals of the Pendaganti Law College, this was 2 rooms and we used to take 2 classes. Room number X or room number Z like this. Then in the midnight, because at the time I came from Osman University. And whatever the function that we want to do with the 200 people or 150 people, we used to go to Osman University campus or any other Tyagaraya Gana Sabha, something. We used to go there. Then what to do? If we want to conduct a small seminar in this campus, here only, something should be done. Then I requested the management, sir, if you permit me, I will break this wall. It's like a Bernal wall. So then these management and very generously and this requested me, or what we call asked me, you break, so what you will do it. Then the first year, and after breaking this one, we conducted 2 or 3 national seminars, and by seeing the what we call utility of this room, or what we call this conference hall, they granted 6 lakhs to renovate it and make it as a number 1 or first class what is called conference hall for 200 or 170 people. So this is a small idea conceived to a small teacher who was at the time was a principal in the midnight. Now you are all comfortable here. You need not go to Osman University campus, and you need not go to there is Bagalingampalli conference hall or Tyagaraya Gansabha, something. So this is I feel proud by seeing that what we can say, you're all here, you're all comfortable and enjoying the privileges of academics. Right. So coming to the 3 important legislations where the government of India directed to commence these 3 important legislations. Number 1 is Bharatiya Nyaya Sanhita, Bharatiya Nagarika Suraksha Sanhita, and Bharatiya Saksha Adhiniyam. So the last subject is my bread, and other 2 are not my cup of coffee, but I can speak but not effectively. I know little bit here and there. So therefore, when your principal asked me to deliver an extension lecture on sensitization of the new law in the criminal administration of justice, then I agreed to deliver a lecture on Bharatiya Saksha Adhinayam, that is law of evidence. So when the name Indian Evidence Act 1872 has been replaced as Bharatiya Saksha Adhinayam 2023, in fact I was not happy, because I started my academic career with the Indian Evidence Act. I was a junior teacher where the seniors imposed me that you have to take law of evidence. But the same subject provided me so many things, number of feathers in my cap, where the National Police Academy invited me to deliver lectures there for 5 years. I was there in the National Police Academy as a visiting faculty to address IPS officers. The sections of the Indian Evidence Act are there and my fingertips. And even in the dream, or what we can say, even in the midnight, if you say, what is section 6? And what is the language? What is section 11? What is section 4? Definitely. But immediately, generally what we'll do is, the moment we read that section, we say it is Indian Evidence Act 1872. Now I cannot say Indian Evidence Act 1872. So for everything that I have to say, Bharatiya Saksha Adhiniyam. So I am unable to digest that because I was accustomed to that, what we call that word, Indian Evidence Act. Right. Anyhow, change is inevitable. Change is necessary. Change is required to meet the contemporary challenges. I am one of the strong supporters that the law should be changed in accordance with the needs of the day. So now the day has come. We have 3 important legislations, and I already told you that I am going to speak on Bharatiya Saksha Adhiniyam. My dear friends, whenever you want to examine any legislation, any enactment critically, when any legislation or enactment is revised, replaced, or amended, or modified, then as a student of law or as a teacher of law, we have to see 3 important facets. This is whatever it may be. Even if the judgment of the Supreme Court is there, a new president has come, and even a new procedure is given, or the new law is given, what is very important is you have to critically examine, because we have to rationally think and critically examine. So there are 3 important facets that we have to keep in our mind. Now I am going to test this Bharatiya Saksha Adhiniyam. That is a laboratory test. Whether this Bharatiya Saksha Adhiniyam has undergone these 3 tests. This is my job today. It's not that what we call, you see, this is this section, you can see that. So that is, you can do it, the table is there with you. But critically, that what we can say, there is one fluid test is there. And whether this test has undergone, that's what we call this Bharatiya Saksha Adhiniyam has undergone this, what we call these challenges of this test. What are those 3 aspects or facets are there? Structural changes. When any law is made, the student should examine, is there any structural change in this legislation or not? Number 1. What is that structural? Order, chain of arrangements, and whether this law is properly arranged or not. Is it no? Everything is covered, every component is covered or not, that we'll examine. That is known as a structural dynamics. Structural change, order, from interpretation clause to repealing clause. That is the last clause of this Bharatiya Saksha Adhiniyam is repealing provision, 170. Introduction, that is Bharatiya Saksha Adhiniyam 2023 is applicable to all India. Now there is no rider, Jammu and Kashmir riders are not there. It's all India means all India. So that is the entire India. But it is that what we call except arbitration, proceedings and affidavits. In others, earlier what was happened now? This is court-martial proceedings were there. This Indian Evidence Act was not applicable to these court-martial proceedings. Now this law is applicable to court-martial proceedings also, please understand. So this is one. And this Indian Evidence Act is not applicable to arbitration proceedings and also mediation proceedings. There is no question of what we call involvement of the Indian Evidence Act or CPC in what is called mediation proceedings. Mediation, we settle our dispute. Why this procedure is required? Why examination chief is required? Why cross-examination is required? So therefore, it is not applicable. What I would like to impress upon you is that the first test is whether it is structurally arranged or not. And second test that what we are going to do is whether this law is properly arranged as far as the functions are concerned. Let's call it functional dynamics. So what are the functional changes that they are made in this legislation? What are the structural changes that they are made in the legislation the government has made? And what are the functional changes, operational? So how the functionaries work, and where do we have to get the evidences? How we will make it relevant? Everything that is functionally. The last, which is very important, is the normative science students, that is the law students, that we have to see is whether there is any normative changes or not. What is the normative change? New law, new procedure, and new rule, new regulation. This is norm means rule. Any normative changes, what we call redefined. For example, document is redefined. Normative changes. These are the three components. You have to see, you have to examine any legislation critically. So this is there any structural, functional, normative changes are there or not. Then before going to this structural, functional, normative facets of this legislation, I want to give a small introduction to these two legislations, Bharatiya Saksha Adhiniyam and Indian Evidence Act. The very purpose, the very objective, and the intention of these two legislations. Of course, Indian Evidence Act is no more with us. Yesterday only that we said goodbye. I know, day before yesterday, I think on 1st July, midnight, at about 12:20, a case was registered in one of the police stations in Gwalior on section 303 of the on 303 of the Bharatiya Nyaya Sanhita, that is called IPC. 303, what is the 303? Don't go to previous 303. What is the present 303? Present 303 is theft. Theft. First case was the theft case. Generally, we remember three important provisions. Normally, even when we see the movies, theft, murder, rape. These are the prime offences that they are there in our fingertips. Earlier, in IPC, it was there in 3.2. Now it has gone to 103. 302, 103. So forward, it was made. Earlier 375, rape. Now it is 63. Earlier 378. Now it is 303. This is called numerical changes. That is not important for us. I am not here to say which provision is transferred here, which provision is transferred. So my job is to give jurisprudential or conceptual touch to the you people on these legislations. Right. What I said is I want to give the importance of this legislations, two legislation. That is itself Indian Evidence Act or Evidence Act or Saksha Adhiniyam. The Indian Evidence Act 1872 and Bharatiya Saksha Adhiniyam 2023, they are fulfilling certain objectives here. They are fulfilling certain objectives here. Now let's see. The first one is, this is the law. This is the law by reference. Which one? Bharatiya Saksha Adhiniyam is the law to govern, to study Bharatiya, Saksha, these are the important facets, student of what we call evidence they should know. This is the law, governs the facts of enquiry, number one. This is the law that governs the facts of admissibility. It is not there. Just I am giving introduction. After that, my slides will come. And this is the law of the facts of relevancy. And this is the law of the facts of examination. And this is the law that governs the facts of proof. For that purpose, I have given a small formula to understand easily, where you can understand very easily. The small formula that I have given, what is that formula is RAE is equal to P. If you want to note down, R, capital R, A, E is equal to P. My dear friends, if you read 170 sections or previous 167 sections, that is a Indian Evidence Act, the scheme is RAE is equal to P. Relevancy of facts, admissibility of facts, examination of facts. The result is, that's all. So what is the purpose is proof. Proof of what? Proof of Jayakumar? Proof of Rajagopal? Proof of facts. That is what, indirectly what we can say is, this is the law that governs the facts. That governs the facts, how those facts can be made admissible into the court of law when there is any litigation, when there is an inquiry. Then immediately my question is, my dear friends who are sitting on this side, what is a fact? What do you mean by fact? Anyhow, fact means and includes anything or state of things or relation of things capable of being perceived with the help of senses. Those who are sitting in this classroom or a conference hall, I think everybody they have 5 senses. If anybody can claim, no sir, I have the 6th sense. If you have the 6th sense, you need not come to the classroom. Just sitting here in the library or sitting in your own house, you can also perceive what Jayakumar is speaking here. But we are all ordinary prudent persons, and we have only we have only 5 senses. So with the help of these 5 senses, where you are capable to perceive things, that is called fact. That too, it is only a physical fact. So this is a physical fact, where you can taste, where you can touch, where you can see, where you can smell, where you can hear. They are all physical facts. Then second part of the fact is psychological facts. What is the psychological fact? The person who is sitting in the last bench and the corner, and he is getting bored, but he is not happy. So therefore, it is a psychological fact. Is it not psychological fact? So we have both the things are required. We need a physical facts and psychological fact. Am I correct or not? So that is why in your IPC, there are 2 important facts that we consider. One is intention. Intention, that is psychological fact. You cannot perceive it, you cannot taste it, you cannot touch it, you cannot do it. It's a mensitria, something is there in his mind. So what is there in his mind, I cannot understand. So this something is there in his mind. It's called psychological fact. Psychological fact will be translated into physical facts. How? The next stage is preparation. IPC teachers, they say preparation. So conceived idea, and here hand has gone to pocket to take the pistol. This is called preparation stage. Then attempts. So this is what we can say. The third stage is attempt. And finally, and that's where it is a commission of an act. These are the 4 stages. That is why, to appreciate the physical and psychological facts, what we need is, we need certain rules. For every game in the sports, we have certain rules and regulations are there. Anybody can deny it? No, sir. For football, there is no need of any rules, sir. They can put it this side or that side. Can you say like this? Sorry. So for every game, even a small game also, even a carom board also when doing it, and there are some rules and regulations are there. You can't put first red and then do like this. So therefore some rules are there. And how to admit the facts in the court of law in inquiry, we need certain rules, certain regulations. Those rules and regulations where you can see in the Indian Evidence Act, now it is made it as Bharatiya Saksha Adhiniyam. So put it a different way, conceptually, the Bharatiya Saksha Adhiniyam is the rules of the game that is called contested case. It is a contested case. In the contested case, there are 2 parties are there. Who are those 2 parties? Petitioner, respondent, plaintiff, defendants. So this is a contested case. In the contested case, we want certain facts, and what we have to, in order to support our claim, that is why certain rules, not according to our whims and fancies, according to our wish, the facts will not be taken. Sir, you take my quote as a relevant fact, sir. Since you are taking my quote as a relevant fact, you take my tie also, it is matching, sir. It is not your matching. So this, who will see whether it is a particular fact is matching or not? Court will see. Suppose bloodstained cloths are there on the coat. This coat is relevant, exhibit 1, but my tie is not relevant. So therefore, which fact they have to take is shall be judged by the court, shall be examined by the court with the help of Bharatiya Saksha Adhiniyam. Please mind it. Right. Now coming to now the slide. Now we are coming to the subject. This is only conceptual explanation given to you. While enacting this legislation, Bharatiya Saksha Adhiniyam, the government of India identified certain objectives. Certain objectives are there. What are the reasons? Amit Shah has no work, Modi has no work, Parliament has no work. Of course, unfortunately 140 members were sent out from the Parliament, and within half an hour all 3 legislations were passed. That was one of the one of the criticism against the government. 140. Yes, you go out. We have the majority. Then we pass this legislation. Deliberations were not there. Of course, it has gone to subcommittee, it has gone to experts committee, it has gone to public, nothing big. But deliberations on the floor, it was not done. Everything within half an hour closed. 3 nilayams, 3 adhiniyams that we have come. That's why Indira Jaising, she went to the court. Sir, as far as the IPC is concerned, we have no any objection because it's a substantive law. It will come prospectively, it will come into force prospectively. Evidence also, substantial changes are not there. Therefore, there is no any objection as far as evidence is concerned. But when it comes to CRPC, there are so many changes are made. Structural changes are made. Functional changes are made. So from tomorrow onwards, we don't have any metropolitan magistrates. Removed. The title itself is removed. Then there is a confusion. So that's who is that in charge. So therefore, certain bottlenecks are there. These bottlenecks will remove it by sitting with the advocates, those who are practicing at the official level, at the ground reality, those who know the ground realities, district level or official level, those who are practicing, what are the difficulties that they are going to face. That will be, okay, sorry, Parliament has taken a decision. It is, as far as the democracy is concerned, Parliament is sovereign. If you want to question it in the form of a writ, but not in the request. Is it all? Supreme Court will not entertain the request. Sir, please examine. Nothing doing. You come with a proper order that's called a writ or whatever, appeal or whatever it may be. So therefore it is not entertained, and midnight it was implemented, and the first case was in the, what is that, Madhya Pradesh, Gwalior, on section 303. Right, okay. Now, these are the objectives, my dear friends. Just I'll read out these objectives and go to the substantive part of the subject. The very first objective is, of course, one of the teachers, while introducing me and also subject, she covered these components. Just for your purpose, just I'm reading out these objectives. One is to replace, rationalize, restructure, and modernize the colonial laws. What is that called? Colonial laws. 1st September 1872 was the day when the Indian Evidence Act was implemented. 1st September 1872. The draftsman was, who is the draftsman? Stephen. James Stephen. Wonderful scholar. Articulation, organization, drafting, presentation. Really it was good. That is why I think that if I am correct, only in one case the provision of the Indian evidence has gone to the Supreme Court about its constitutional validity. That is only one time. If any legislation is drafted, definitely some provisions they will go to the Supreme Court and challenge it about its constitutionality. But never, Indian Evidence Act, never. Only one time, section 27 of the Indian Evidence Act, that was challenged and Supreme Court not accepted. So therefore what I say is, if you draft the legislation, articulate it, organize it, and make it properly, and it will serve the purpose. That is why even today I say that the Indian Evidence Act is a wonderful legislation, a piece of legislation. To draw your attention, I want to read out previous section 4 of the Indian Evidence Act. Previous section. Now it is merged into section 2. What is that previous section 4? Wonderful provision. That we have to read that section 4. There are 3 paragraphs are there. The first paragraph says, whenever it is provided by this act, underline the word provided. Whenever it is provided by this act, the court may presume a fact as if it is proved, unless until it is disproved. Language. Second part. Whenever it is directed by this act, the court shall presume a fact as if it is proved, unless until it is disproved. Second part. First part, provided. Second part, directed. The third part is, whenever it is declared by this act. Declared. Suppose the principal says the college is closed and declared holiday. Is even one fellow will come to the college? Declared, sir. That's all. Whenever it is declared by this act, and the court shall presume a fact, and no contrary evidence is allowed. Sorry, I am extremely sorry. The Indian Evidence Act declared that it is concluded. It's called conclusive proof. May presume, shall presume, conclusive proof. Now, we don't have any guts to remove that paragraph. We included it in section 2 of the Indian Evidence Act. That is Bharatiya Saksha Adhiniyam, section 2. Earlier it was there in section 4, now it is 2. So in the 2 there are so many paragraphs are there. They are alphabetically arranged. So that is why students please note that may presume, shall presume and conclusive proofs are alphabetically arranged. Earlier may presume first, then shall presume, and next one is conclusive proof. If you alphabetically arrange, then which is first? C is the first. So conclusive proof is the first. Like this under section 2, this under the differential clause it is included. Beautiful language. So therefore, one more example where we always discuss with your professor Mohan Krishna sir, how it is wonderfully that is articulated. section 11 previously. Now it is 9. Facts not otherwise relevant become relevant. తెలుగు వచ్చు కదా మీకు? వాడు మనిషే కానీ మనిషి కాదండి. వాడు మనిషే కానీ మనిషి కాదు. ఏంటి మనిషే కానీ మనిషి కాదు? ఫ్యాక్ట్స్ నాట్ అదర్వైజ్, మామూలుగా అయితే రిలవెంట్ కాదు, బట్ రిలవెంట్. ఫ్యాక్ట్స్ నాట్ అదర్వైజ్ రిలవెంట్, బట్ రైడర్ ఈస్ దేర్. వాట్ ఇస్ ద రైడర్ ఈస్? ఇఫ్ దే ఆర్ ఇన్కన్సిస్టెంట్, facts are inconsistent, highly probable, improbable. It cannot be. For example, I give you a small example. So we are conducting a small death anniversary ceremony of a particular X in this room. Okay? Death anniversary that we are conducting. So he is a very nice man. Previously he was with us, and now we are conducting the death anniversary. Photo is there this side, and we put it, garlanding, everything that we have done. Everything we have done. Mohan Krishna sir has come and he spoke something. Others, sir has come and spoke, madam also, everything. Then from student sides also, some people they spoke. Then they said, only one chance is there, only one speaker, because it is already 2 o'clock, there is only one speaker can do. Then one fellow is coming slowly, like this. Sir, I want to speak about X, sir. X is a very nice man, like this, everything. Who is that X? I am the X, sir. For whom that we are conducting the anniversary, that he is present in the hall. And he wants to take what we call lunch also with us. Then some people, they run away. Oh, a ghost has come. No, sorry, it's the same person. This is highly improbable, inconsistent. He is a dead, wife certified, dead, relative certified, everybody said. But suddenly he appeared. It is a death anniversary ceremony. What is this? What is this? Highly improbable. So this is what we are taking, section 11. 11 speaks about highly improbable, highly impossible. It's not possible at all. If you know, that is a LEB, you are giving the LEB is the best example for a section 11. Now section 9. So that fellow was there in the classroom while he was delivering it. But then the situation comes, no. On the same time, 10 o'clock, I was in the Ram Manohar Lohia Hospital. Ram Manohar Lohia Hospital. Is it possible? Same fellow, same time, and Pindaganti College premises, and appearing and admitting. Not appearing, admitting. We have the everything, the electronic evidence is also there. So therefore, is it possible? It is an inconsistent fact. That is what section 11 speaks. So that is highly probable or highly improbable, highly inconsistent, the facts that is right. That is the beauty of the Indian Evidence Act. And I draw your attention, my dear friends, you need not worry. Jay Kumar is also need not worry. And because of the change of the title, 95% of the Indian Evidence Act is structurally, functionally, normatively retained. If this secret I would have told to principal sir, principal madam, sir, why you need, we will tell that word. So I will announce it to all the students. So 95% is retained, only 5%, that the grace marks that you can pass it. Sorry. Madam would have announced it one single, Jay Kumar sir, expert in law of evidence, he said that 95% is retained, and even though that is the Google also we can see 95% is retained. If the 90% is retained, what is there? Structurally, functionally, normatively retained. Only one provision is a new provision added. Please, my dear friends, only one provision. That is normative, section 61. Section 61, Bharatiya Sakshadini. That is the original source. Others are added from here and there, already they are in existence. That I want to establish it, how they are retained it. Okay, now you read it. To meet the modern and contemporary issues, to provide general principles and rules of evidence, these are all what we can say. To meet the technological advancements and to meet the corresponding changes here and there. If you see section 2, clause 2, that is the differential clause. What it says, if you have any doubt about the interpretation of any word, definition of any word, while you are implementing the Bharatiya Saksha Adhiniyam and you cannot get clarification from the act, that is from 1 to 170, you can't get, sir, I am unable to understand about this word, then what the section 2 clause 2 speaks is, if you have any doubt, go to CRPC, go to IPC, that is called, what we call Sanhitas, or Information and Technology Act. These are the three important legislations that we have to refer. Sir, I have a doubt to interpret, I have a doubt to apply this principle to existing facts. But clarification is not there. When you have no clarification, read Information Technology Act 2000 or Bharatiya, IPC, Nyaya Sanhita, and CRPC. You read all these provisions. Right? These are the only two direct provisions. What is section 61? 61. You please tell me what is section 61. Suppose, what do you want? Rajgopal sir and Jaykumar sir are the senior teachers here in this room. We have some blocks. Please, we don't like this technology. What is this technology? Once upon a time, I was against this PowerPoint presentation. I always say to the students, it's not the PowerPoint presentation, it's a powerful presentation is required. Okay? Suppose we are all against the technology. And incidentally, we are the judges. Now, when the parties come to the court of law with a piece of evidence, and another piece of evidence is, sir, we have the, what is that called, a cell phone is there, sir, mobile is there, and in this mobile, everything is recorded. So therefore, you please admit this mobile as exhibit 1, and whatever the contents are there, those contents you take it, I will give a declaration, and you verify it with the examiner, what is called expert. This is what the contents of the respondent or petitioner, whatever the case may be, before the bench of Rajgopal and Jaykumar. We are traditional people now? No. We don't allow all these technologies, all these things. What is this? No CD, no to the telephone, no mobile, nothing doing. If at all there is any printed copy is there, any document is there, any original document is there, that you produce it. That's all. I don't know what to take. Then 61 says, Jaykumar, Rajgopal, shut down. You are not supposed to speak like this. So no person can deny, no judge can deny that the electronic evidence is a piece of evidence. They are bound to allow. If the electronic, what is electronic evidence? This is defined. It is there in the act. So whatever the electronic evidence is produced before the court of law, there is any other alternative to the court to it should admit it. This is the only original provision in the in Bharatiya Saksha Adhiniyam. Other things are tinkerings. Tinkerings or additions or deletions or something it was done. So therefore don't worry, and only worry is, again, if I want to teach Bharatiya Saksha Adhiniyam, I have to by heart that sequence of provisions. So corresponding provisions. So in CRPC, it's also the same difficulty. Previously, murder means 302. Now we have to search where is that murder. So murder is murder forwarded. 103. 302. 100. So this is very interesting, right? The next slide is next slide. There also, you please go through it. Operational dynamics of the act, expanding the scope of admissibility. Anybody's subject itself is very hard. If anybody is what we call feeling bored, you can ask me that I will give 5 minutes time and I will make you what we call get up, get down, and pitcher mood, dahina mood, tina dahina chilinga. So within this, where you can flexible and what we can say, you can get some blood circulation. You're all young people, only these people have to go out. The reason is blood circulation stops. But for you, there is a question of you in the flight, 12 hours, 13 hours, you are going to the United States of America, that is only small seat is there. This is not economy seat. They will sit, okay? Mind circulation stops. 40, right? You agree. 40 minutes is the right time where it goes to the person. So, okay, madam, what will do? What will do? My target is 1 hour you are close also, there is no problem. But only thing is I should reach to each and every participant without any intervention. So for that purpose, if you want anything, if you want me to sing a song, of course I cannot sing a song. So this is something we can do. This is the state teacher's strategy. So to draw the attention of the students. Is it not? Right? Right. Now I am coming to the subject. Next. Pardon? Yeah. Right. Now, you go to very interesting area that I have come. So you'll also like, my dear friends, these parts. Because if masala is there, you like it. If the bagar rice is there, don't like it. Bagar rice don't like it. But masala, if you put more masala, which leads to gastric trouble, then that you like it. Now that you... Right. Okay. Now I am going to add something to you. My dear friends, please, these are the cases already you studied. These are the cases that are very, very important areas that I am going to touch. Before making this structural, functional and normative changes in the Bharatiya Saksha Adhiniyam, we have already achieved these objectives. Whatever the objectives that we mentioned there, already we achieved it. The first time, my dear friends, the Indian Evidence Act was amended, first time. Of course, small amendments were there, that's different. But important amendment that's called a normative change was done in the year 1983 as a result of famous Mathura's case. Mathura resulted 1983 amendments to Indian Evidence Act. Now it is included in Bharatiya Saksha Adhiniyam. What is that Mathura's case? That was also popularly known as Tukaram versus State of Maharashtra. In that case, what was happened now? A girl, innocent girl, tribal girl, illiterate, she went to the police station at the sunset along with the parents to submit a FIR, what we can say, information to the police. Something it was happened to her. Then the police, they jotted down and requested the parents and the relatives, you go outside, I will keep this girl, we want to get some information from that. It was sunset. And these relatives are staying nearby, outside only. It's maybe 200 meters or 300 meters like this, nearby. In this absence of these parents and relatives, there were only two senior constables were there. Tukaram was one of the constables. Even not, what is that called, in charge inspector like this. And they used their manpower, muscle power, and committed rape. 375, read with 376. There was no any alarm from that side, no cry, and act was done. And then she informed to the parents after going outside. Then immediately, that is what we call the entire Tanda has come. What is that? What is then they forced. That was one of the interesting case where the accused persons jotted FIR against themselves, charge sheet against themselves. So this is Tukaram against Tukaram, written by Tukaram. So this is a case, interesting case. Then, okay, it has gone to the district court. I don't want to travel here. Ultimately, it went to the High Court, Maharashtra High Court, wonderful judgment, Maharashtra High Court. But unfortunately, that was reversed by the Supreme Court. That is very sad. When the matter went to the Maharashtra High Court, it was argued by the accused person, that is the advocate. It is not an accused person, advocate will argue. It is his brainchild. What he said, sir, They are all in the walkable distance. There was no any cry. There was no any alarm. And there's nothing, physical injuries are not there. So therefore, this act is not the act against her wishes, without her consent. It was an act of consent. Generally, if it's an act of consent, it will not attract under section 375. Read with 376. How can you book this case, wrong case under 376? It is a consented act. It is a consented act. Suppose if the police constable has committed a mistake within the police station, you punish him, sir, 3 months imprisonment or something, you can do it. But not under section 376. Read with, 375, read with 376. It is a consented act. Then Maharashtra High Court said, what are the circumstances? What is the nature of the girl? Age of the girl? And cultural background of that girl, the place where she was, first time she entered into the portals of the police station. By taking, it was interpreted by the Maharashtra High Court, it is a passive submission. Passive submission amounts to an act of, even if consent was there, maybe ultimately consent was there, that's why they are. It's called passive submission. She herself surrendered to those mighty people. That's called for the muscle power and manpower. So therefore, it is a consent. It's not a consented act. It's a passive consent. Passive consent amounts to against her will. Against her will. Therefore, it attracts section 375. Read with 376. Then, when it went to the Supreme Court, they examined other evidences, of course, and ultimately the Supreme Court said benefit of doubt was given to the accused. That is the only remedy given by the Supreme Court. That is the only remedy given by the Supreme Court. Benefit of doubt was given to the accused. Accused was acquitted. Then there was a hue and cry from the society. Hue and cry. This was the 1972 and 73 case. There was a pressure on the what we can say our Supreme Court. At the time, 13 judges were there. 13 judges, 73, 13 judges. Kesavananda Bharati's case was also decided in 1973. And this is, no, it is not in our hands. Ultimately, the Parliament has to make law and what we call decide it. As a result of that case, in the year 1983, section 114A, please see, 114A was added. 114A. What section 114A is? What is 114A? Presumption as to what we can say custodial rape case. Custodial rape. What is the custody? Where the rape committed in the police station, rape committed in the hospital, rape committed in the working place, and rape committed against the pregnant women, rape committed against rape committed by 5 or more persons, gang rape. These are all fall under custodial rape. So therefore, the court shall presume, generally, accused person is innocent till the guilty is proved. It is the prosecution has to establish the case. But in this presumption, what it say, burden of proof lies on the accused person. It was not the rape, it was a consented act. So this is one of the normative changes already made. Now we adopted under the Bharatiya Saksha Adhinayam. Normative change. That is a law has changed. The next one is section 113A and 113B. They are enacted as a result of Dowry Prohibition Act 1961. So in order to satisfy the provisions of the Dowry Prohibition Act 1961, 1961, two provisions were added. 113A. 113A is a may presume. I already told you. Court may or may not. What is that 113A? Where there is an abatement for commission of a suicide by a married woman within 7 years from the date of solemnization of marriage. So it's a doubtful case. That's what we call abatement was done. Consequently, attempt to commit suicide was done. In that case, by seeing the circumstances, court may or may not. That's called may presume. But when it comes to 113B, where there is a dowry death, prima facie case is established. It is approved. Dowry death, prima facie case is established. One or two evidences, direct witnesses or what we call some witnesses. Court believed in it. Yes, my dear accused person, it is your turn to establish the case. I believe, I draw an inference that you have committed the crime. No doubt you disprove it. Unless until it is disproved, the court shall presume. Court has no alternative. So court cannot say, no, accused person is my friend. I know about his character. He is having consistent good academic record and good character is there. I will not believe. You please establish the prosecution. Sorry, sir. See section 113B. 113B says, what says? Court bound to draw inference. Then allow the other party to disprove it. This is also a normative change. Normative change. The third important is that section 65A and 65B are added in the Indian Evidence Act as a result of Information and Technology Act 2000. And in our college, experts are there on these cyber laws, IT. I'm the poor person having that some knowledge about only this latest technologies, technology law, everything. That is why in the appropriate context, they will explain what are the developments as far as the technology is concerned. Anyhow, 65A and B were added. So now, apart from 65A and B, I already told you there is one more section was added that is called the rider. That is the rider. That is called, now you see, 61, 62, 63. These are the three provisions are added, and with this, the court is bound to take care of, bound to allow what is that called this digital evidence, or what we call digital documents, all these things. So this is also there's a functional change as well as normative change. We have already done. We have done. In the 2000, it is not that the 2023 that we are doing, it is already we have done it. But some cosmetic changes here and there, some cosmetic changes they did it in 2023, now we are implementing. So what I am saying is I am going to establish everything, whether this law was there earlier or not. I already told you we have to examine whether there was any structural change, whether there was any functional change, whether there was any normative change. So this is also a normative change. Another important one is, I will bypass certain few things. A provision was added to section 146.3 of the Indian Evidence Act. Now it is reflecting under section 149. What is this provision is? Victim of a rape case. In number of cases, the victims are not cooperating. Victims are not coming to the courts and giving evidence. Prime witness is the victim, that is a rape victim. Why? Because of you people. Because of you people. Because of ours. Why? We are the persons who are going to represent the case. Am I right or not? Tomorrow. I'm going to represent my case. My case, what we call, accused person is by client. So I have to get the benefit to him. Then I will put the cross-examination. Or the cross-examination, indecent questions, vulgar questions. Of course, judge, he is sleeping. Cross-examination is always in the afternoon. He is sleeping like this. This fellow will put questions. Of course, in-camera proceedings are also there that they can ask. Even in-camera proceedings also they put examination. Delicacy is there. To avoid this delicacy, witness is given protection that you are not supposed to put certain questions which affecting her previous bad character. What is the bad character is? This fellow says, sir, this fellow has committed a rape. Now the advocate, how that he is arguing, sometimes, sir, this lady is a professional prostitute, sir. She is running a house, sir. So therefore, it is open to everybody, sir. Just like a Bawarchi. Everybody can go, sir. But this lady, why that denied only to this fellow? So here he is, since he has agreed, my client has committed an act, but it is committed against whom? Against the women of easy character, or what we call easy character. So therefore, you have to take it lightly. You have to take it lightly. There was a case, I'll tell you before this. State of Maharashtra versus Madhukar Narayana. This is a case, 1991. State of Maharashtra versus Madhukar Narayana. In that case, what was happened now? A police inspector committed a rape against a woman who is living, or what we call staying, in a prostitute home. Now the case is filed under section 375, read with 376. His contention is, sir, that is the place of sale of the flesh. Place of the sale of the flesh, I have gone there, that what we call, I utilize it. How it is an offense? Then Maharashtra High Court, very liberally, literally, no, we will not believe what we call the women of easy character about her testimony. Therefore, benefit of doubt was given to the benefit of doubt was the accused person. Then the matter went to the Supreme Court by special appeal, and Supreme Court blasted here. The doctrine developed in that case was that student of constitutional law should know it. Even a woman of easy virtue has a right of privacy and human dignity. Human dignity. Just because she is a prostitute, you cannot demand where she has to mend or bend her body, or where she has to what we call give her consent. It is her wish, not that every fellow. So therefore, even agree that she is a prostitute by circumstances, by cultural. So therefore, even a woman of easy virtue, easy character has the right of human dignity. Human dignity not for only Pendeganti boys and Pendeganti girls and Pendeganti teachers. So even fellow that's a bystander, or what we can say the fellow who is working what we call some filthy job, that fellow is also having human dignity. Am I right or not? Are you agree? So it is not our privilege. It is not our privilege. It is a privilege of every citizen of this country, human right. That was as a result of this judgment. There were developments were there. This is one development, and you see the other cases. Other cases also same. Criminal Law Amendment Act 2000 was made, and 53A was added. Women outraging the modesty of women, and questions cannot be put previous character. So when somebody, suppose one cinema actor has come to the witness box, she is the victim. Sir, one fellow who is a pedestrian in Pendeganti Law College, pedestrian, not a person from the Pendeganti College, touched my body, sir, and inappropriately. Then the claim of this pedestrian is, sir, Chiranjeevi touched, no refusal. And of Chiranjeevi brother touched, no refusal. And the cinema actor, I don't know what is the name, you please tell me. All these people, they touch it, sir, not beyond that. What I touched, beyond that they touched it. But when there is, everybody is touching, and when it's also not an offense, then what about just because others touch for a purpose of, you are not supposed to touch. So this is, what about her previous bad character? Her bad character is taking the consent everybody to touch. Previous bad character is immaterial, whether you touch it or not. Yes, I touch it. It's an offense. So this is an evidence. That's what we call section 53. Then same thing, the rape victims also it was happened. And ultimately, we have the Bharatiya Saksha Adhinayam. There is only one slide is there, salient features of the Bharatiya Saksha Adhinayam. And this is for examination purpose. If any question is there in the examination, what are the salient features of the Bharatiya Saksha Adhinayam, then you have to write down. Not this what Jay Kumar said, this what you touched, not touched, or the Madhukar case, and all these things. This is only for the purpose of you are understanding the concepts. Please understand. Am I correct? Right, now you go to. Right. I cannot mend my body, bend my body. Right. Now, quick, 5 to 6 minutes, quick responses. Number one is, Indian Evidence Act is completely replaced by the Bharatiya Saksha Adhinayam with 95% retention. Keep this point. To tell that 95% as it is retained, but replaced. Why it is replaced? Title is changed. That is why I tell you, we have the Priya Chettis are there, no? Priya Chetti. So you put another bottle and Priya Chetti there. Taste is the same. Right, for you, that's I'll give another example. Old wine in the new bottle. Old wine in the new bottle. So it is a Scotch whiskey brought to Hyderabad, and there is a local, what we can say, made, what is that, bottle. They are putting it outside, what is it called? Indian whiskey or Indian Scotch, not like this. But so old wine in the new bottle. Here also, Indian Evidence Act title is, the title page is removed and a Bharatiya Saksha Adhinayam is, okay? This is point number one. Point number two, don't write this explanation. The explanation is only to understanding. Scotch whiskey, all these things by J. Sir. So I have, because once upon a time I was a board of examiners, and the court paper will come, J. Kumar sir categorically said it is, don't write. So understand the point that you have to write. Then next one is, present act consisting of 170 sections, 169 only substantive provisions, so 170 is the repealed provision. It's called, we are repealing the Indian Evidence Act. If that is not there, that is, suppose the 170 is not there, and the court will take Indian Evidence Act also. Then why that you are taking Indian Evidence Act? Sorry, it is not repealed, sir. You see, where is the repeal? Go to 170. In 170, Indian Evidence Act is repealed. In that place, we have Bharatiya Saksha Adhinayam. That is called, it's what we call functional dynamics. It's a functional dynamics. The next one is, the Act is applicable to all proceedings, including court-martial proceedings, except arbitration proceedings, affidavits, and mediation proceedings. Already told you. This point you have to write. And the next one is, all definitions are there under section 2. Previously, all the sections were there, all the definitions were there under section 3. Now they are brought. And similarly, section 4 is also pushed to section 3. So there, 4 disappeared. I am unhappy. So I am very unhappy for that's what we call not giving a special or the conspicuous provision for section 4. Now, the next one is, you please read this paragraph. This is a functional change. Next slide is. What is the next slide? What is that? No, self-put is the next slide. Any marking is done there? No, nothing. Because I am reading. Okay. The key words in the definition of evidence is electronic statements given electronically. That is a newly added, and this was already there under the Information Technology Act. So electronically, it's already there. This is a functional change. Electronic or digital records produced for inspection of the court, such a document shall be called as documentary evidence. What is the documentary evidence previously? Documentary evidence. So anything is expressed or described upon any substance for the purpose of recording by way of letters, figures, marks, etc. there. Now, this is also what is the electronic, your pen drive. So the example is there. You please see the example. Some examples are given for the electronic evidence. Electronic documents, some examples are given. I need not. You can. The next one is definition of document. In this definition of document, you read the second line. In the definition of document, second line you read. What is the second line is? You read it, document means express or describe, or that is the keyword. That is the keyword. Other things, other. This is the new word added here is. Otherwise means you can also send electronic documents. This is that we have to take it. Because of paucity of time, I am not going to extend it. So these you take it, and you can also take my PowerPoint presentation. So, sir, right. I think that okay, there is no problem because you are advanced. I am the only person still in the 1950. There is a love story. Right. Next one is next. You go to next slide. I have to quick. Right. 2 minutes. Can't you wait? Can't you wait for me? 2 minutes. This is for your examination. Tomorrow definitely there is a question. What are the salient features of the Act of 2023? So of course you have some series are there and they quote or misquote, but Jayakumar will not misquote. Right. Number one is relevancy of facts. Earlier 5 to 55 was there. Now it is reduced, so now it is now come down. Let's call it 3 to 55. Why 3 to 50? Why this 350 has come? Two provisions were removed there. One is the 3 is removed and 4 is removed. Everything is brought. That's why shortage. So therefore now 3 to 55. My dear friends, relevancy of facts is the heart and soul of the entire Indian Evidence Act. Rajgopal sir is there. If you have any doubt, go and get the clarification. Heart and soul. If at all heart, if at all soul, that is the area. If you become an expert in that area, and definitely you will succeed as an advocate. The reason is, whenever you are bringing any evidence, when you are getting any evidence, the judge will ask, my dear counsel, and which provision of the Indian Evidence Act you are requesting to put this evidence? Sir, C5 to 55, under section 6, under section 7, under section 8. Suppose, sir, not according to Indian Evidence Act, according to my wish, sir, your wish is not required. It's called logical relevancy. What is required is legal relevance is there. If you want to take a particular fact is legally relevant, that should pass the test of 3 to 3 or 4. What is this? Yeah. Now it is pass the 3 to 50. That's now is 5 to 55 previously. Then admissions, statements made by persons and accepting their liability. Right? Admissions, where you can see from 15 to 27. Then another important is that is called confessions. So confession made to friends, extrajudicial confessions, confession made to police, confession made to the custody of the police officer, and incriminating facts recovered from the possession of the accused person in pursuance of the information given by the accused, any incriminating facts. So they're all relevant here, that where we can see. You please read it. Next one is experts. Expert is a person who is especially skilled in foreign law, art or science or identity of handwriting or identity of impression. Now includes electronic examiners are also experts. Now from tomorrow onwards, many things will go to the electronic experts instead of Jayakumar, X or YZ. Sir, you please come and witness. Sorry, not necessarily electronic examiners are there because number of electronic evidence that we are going to admit it. Then next one is judicial notice. So there is some provisions were there. Judicial notice. These were all deleted and some examples were deleted. What are those examples is, what is happening in the United Kingdom, why we need the proceedings of the parliamentary proceedings of the United Kingdom. All these things, they are all removed, my dear friends. You can, they are all only cosmetic changes. Now next, you go to the next slide and take the nomenclatures. From tomorrow onwards, even if you do your law at United Kingdom, after coming here, you will not be bar at law. You will be called as an advocate. This is wherever the word bar, this advocate is there, vakil is there, barrister is there, and pleader is there, and it is replaced from tomorrow onwards. Advocate, senior advocates, all these things are there. Advocate, now we are advocates. Not that I am a pleader, I am a what we call attorney, I am a vakil, all these things are there removed. Then next one is, accomplished shall be a competent witness against the accused person, and conviction is not illegal if it is proceeded upon the earlier uncorroborated was there, now it is made as a corroborated. So therefore, if the corroboration where we can believe what we can say, who is the accomplice? Accomplice is a person traveled, sailed together with the accused, main accuser. Lastly, he converted, baptized to the prosecution side. So he has gone to the prosecution side. So we have a doubtful. So for that purpose that we have a provision. These are the some important changes. And for short questions we can, and long questions we have to elaborate all these things. So with this, I take this opportunity. Last slide is thank you. I have given 1.5 hour time. 1.5 hour I retained you with a great difficulty, with a sweat, all these things. This is my success in the classroom. Okay? Ma'am, anything? No. It's fine.
Okay, sir. Thank you, sir, for your thoughtful insight into this newly introduced Bharatiya Sakshya Adhiniyam, and it will also help our students in understanding it in much simpler way. And I would also like to thank you especially for the formula which you have given, that is RAE is equals to P, which will help us to remember this new Bharatiya Sakshya Adhiniyam in a sequential manner. And also I agree on one point with you, sir, that is Bharatiya Sakshya Adhiniyam and also the other laws are just nothing. It's an old wine in a new bottle. Thank you, sir. Now, at last, with this beautiful session, I would like to call upon Manikamba ma'am, Assistant Professor at Pendakanti Law College, to give vote of thanks.
Thank you, Afifa. Good morning, everyone. On behalf of Pendakanti Law College, I am pleased to convey the gratitude to our distinguished guest, Professor Y.F. Jayakumar sir, for accepting our invitation and being here today for delivering this elaborate lecture and summing up the act, that is Bharatiya Sakshya Adhiniyam. Thank you so much, sir. You have rationalized and critically examined and have put an overview on the act and the three tests, that is structural changes and functional changes and normative changes, which are most important for analyzing the act. You have highlighted the act in such a nice and simpler manner, sir. And the importance of the facts, that is inquiry, admissibility and relevancy of the examination of the facts. Thank you very much, sir, for summing up the whole act in such a short time. I further extend my sincere thanks to our management and Principal Dr. Arvinda ma'am for their consistent support in conducting lectures like this. Now let us give applause and heartful appreciation to all the faculty, students and staff, and to all those who have contributed in making this event success. And my heartfelt gratitude to Bhaskar and our technical support, Ishaq and Jatin, for conducting online and offline mode. Thank you, everyone. Thank you, sir.
Students, keep seated, please. Students, keep seated, I said, please. Okay, now move one by one towards your classes. Your respective teachers will take your attendance and then will leave you for your lunch.